Hello and welcome to another episode of your Retirement Planning Simplified. I'm Joe Curry, along with my co-host, as always, Lindsay Wilson. How are you, Lindsay?
I'm great, Joe. How are you?
I'm good, thanks. We're in the final push here before you're off on, I guess we'll call it sabbatical for a month.
That's right. To do fourth line theater, play called Jim Watts. But another thing we're excited about is we have our annual client event this Friday.
That's right. So,
Yeah.
one thing from experience we know is that a lot of people don't know what papers to get rid of, and 20 or 30 years later, there's a lot of tax returns and investment statements and things that pile up. So we're going to get to see a lot of our clients, have some food, some music, and maybe help them get rid of some of those, I guess, confidential papers in a secure manner. So that'll be fun.
Yeah, it would be great to see everybody. Yeah.
Okay, so for today, Lindsay, I know we've talked a lot about estate planning over the last year, but it's just something that we've been talking with our clients about a lot. It's been a big focus. There's been some events with our clients, unfortunately, where we've been kind of going through this. So just wanting to make sure again that people are having the information about today specifically what does it look like to do proper planning specifically with your will, like what are the considerations that we need to think about, maybe some of the things that are often forgotten. So I thought we could just kind of go right through the basics, specifically for the will.
Sure. So I think a good place to start might be just talking about executors.
Yeah, sure. So one of the first things you need to decide is who is going to facilitate the process of distributing your estate. So that is your executor, and this could be one person. So you could just assign one executor. You could have multiple. Now, if you have multiple executors, so maybe it's you're going to be your kids, for example, and you have a couple of kids. They could be just joint, where they both basically need to sign off and agree on everything. Alternatively, it might make sense to have that designation as joint and several. The reason for that is, something happens to you, maybe one of them is living at a province, for example, or is just away, or has something else going on in their life where they're just not really able to make that commitment. So by having it several, it just allows one or the other to carry out those actions. So that's an important consideration. And there also might be reasons why you don't want that, but just something to know. Additionally, and we've talked about this in the podcast, I think before, but being an executor can be a pretty big job, right? And it's not everybody is cut out to be an executor. Sometimes, we assume our kids are going to be, but sometimes you don't have kids, or maybe kids are out of country. So, for example, my brother-in-law, he's out of the country. So if he was my in-law's only child, like probably wouldn't make sense for him to be the executor.
Hmm.
So, a lot of different reasons of why you might not want to choose a friend or a family member to be an executor. And so, you could enroll the or a professional executor. So, there's trust and estate services. There's some of the big banks. There's also a company that we use, Clear Estate, and you can work with a company like that, and they will carry out the entire process. And that's also maybe the last thing I'll mention on this is if you are an executor and it is an overwhelming position that you're in to be able to deal with this, especially given the circumstances. There are services like Clear Estate who will kind of take that off your hands. So there's different levels of what that looks like. So for a I would call it, for most people, a nominal fee relative to the size of most estates. Even if there's just a house there, you can get a lot of help with that, or even have it completely taken off of your lap. So,
Hmm.
just a few different considerations when we're thinking about the executors.
And maybe you could speak a bit about scenario planning.
Yeah, sure. So, typically, there's three scenarios that you want to think about the outcomes for if something happens to you. So the first scenario is if you have a spouse, you pass away and your spouse is still living. So you're gonna have your retirement assets, which are probably gonna roll right over. You can have successor annuitants right on your accounts. So it's kind of like a beneficiary, except meaning it just rolls right to your spouse. The accounts stay in place. So that's like tax-free savings accounts, RRSPs, RIFs, all that kind of stuff. Um, Ideally, you have everything in joint accounts and your house is joint. So everything also just rolls over with no tax consequences to your spouse. Um, and so that's kind of like the most simple scenario, right? Now, if you don't have a spouse or your spouse predeceases you, so you're the only one still living, and you have kids, now we're planning for our descendants only scenario. So in that case, it's okay. If I pass away, it's not nothing's going to my spouse. Where's the money going? So that's the next scenario that we're thinking about. And this is one where we need to think about taxes too, because if there's no spouse to pass things to, then there's going to be probably a big tax consequence, or there potentially
Mm.
could be. Um, those are the two that people don't usually forget about. Those are usually planned for those two scenarios. But then the last scenario is no descendants. So, and this is not something fun to talk about, specifically if you have kids or grandkids. But if you were in an accident, like on a family trip or something like that, you also want to think about, if there's no descendants, where are your assets going, right? And this is something that we honestly we rarely see this in wills, and hopefully it's not something you ever need to deal with, or that needs to be dealt with. But on the same hand, if it is a scenario that does come up, unfortunately, you probably still want to have some say in what happens to your assets,
Mm.
right? So we want to make sure we're including that scenario as well. So those are kind of the three different scenarios. So with a spouse, with descendants only, or no descendants.
And could you explain the term per stirpes?
Sure. So basically, what per stirpes means is, if you have kids, for example, and your assets are going to be going to your kids. Well, if one of your kids passes away, it just means that you're going to essentially keep those assets down the same bloodline. So if there's two kids, for example, they're both 50% beneficiary on everything. One of those kids passes away, but they have kids, then their share of the estate would then pass on to their kids, right? So there's another advisor who I did some education with many years ago, and this actually was an issue with her. Her parents' will did not have any kind of per stirpes or kind of pass on to their issue. There's another
Mm.
wording you might see in the will, but basically, her parents passed away. Sorry, her grandparents passed away, and her mom had passed away before the grandparents.
Mhm.
So what happened was that she didn't get any of her mom's share of the inheritance. It all went to her aunt because it wasn't properly worded in the will. So that's just something we want to make sure that that wording is in there. Usually it is something. If the will, obviously there could be some personal preference, but nowadays it's very common for relationships without marriage, right? And having kids without being married. So in some older wills that haven't been updated in a long time, we have seen in there basically per stirpes, but only within marriage, right? So out of wedlock children being disinherited, basically.
Mm.
So obviously that's up to you if that's what you want to do, but I think that was something, again, looking at older wills for clients who maybe updated their wills 25 years ago, something that's never been updated, and is something that for most people, I think they probably want to change the wording on that, right? So that's something
Mhm.
else to look at.
Mhm. Now, what about restrictions on gifts or trusts?
Yeah. So when you leave a gift, basically there's an outright gift where there's no restrictions on it, or there's some kind of a restriction. So in other words, this money's left to so and so, and if you say but, basically that means you need to set up a trust. So there's going to be a trust in the will. So some scenarios where we might see a trust set up. So one is if there's going to be minors, but potentially money left to minors. So if you're so for a lot of our listeners, it might be more, if something happens to your kids, it's your grandkids. And this is a reason why sometimes this gets left out of wills, is because people aren't thinking about leaving money to their grandkids. They're thinking their kids are going to get the money and they're not minors anymore.
Mm.
But again, there is that potential that something happens to your children first. And if it passes per stirpes to your minor grandchildren, you want to make sure that you've talked about how that's going to be handled. So you got to figure out who's going to be the trustee, like who would look after that money if their parents aren't here. Or if it's just going to them directly and their parents are still here, maybe the parents would be the trustee. Beyond the trustee, though, is when do the kids get the money? What kind of restrictions are there on them getting that money, right? So, pretty commonly we see that, minors don't get the money until they're 25 or they're 30 years old, right? But the trustee might have the discretion to give them some money from the trust to pay for school, to help them with the down payment on a house and things like that, right? So the trust is really allowing you to have some control from the grave. Another scenario is if there's a disabled child. So they might be an adult, but they might not be able to handle their inheritance because they're just not fit, or maybe they don't want to get their inheritance directly because maybe they're getting support from the provincial disability support program, right? Like ODSP here in Ontario. So in that scenario, you might want it to go to what we call a Henson Trust, which is a discretionary trust, and you have a separate trustee, and that does not form part of the beneficiaries' assets for calculating whether or not they can get those support benefits, right?
Mm.
And then other reasons you'd have a trust would just be, if for whatever reason you just don't feel someone's fit to receive your inheritance. Maybe it's because there's a spendthrift. Maybe there's other social issues that you're worried about them getting too much money, and you just want to have some control over that. So you could use a trust. And the last thing, I won't go too much into this because we recently just did an episode on it, but spousal trust. So you might use a spousal trust if you want to make sure your kids get your money or your assets or a certain portion of those assets anyway. But before it goes right directly to the kids, if your spouse is still alive, you might want them to still benefit from the income that's coming off of those assets in the meantime, right? So that's a way to make sure that your surviving spouse can't basically gift those assets to anyone else in the future when they pass away or spend it all. So your kids are going to get some, but it also allows them to benefit from it. So yeah, we did a whole episode on that.
All included in the show notes.
Perfect.
What about distribution of assets?
Yeah. So basically, there's three things to consider on distribution. So the first one, which we can't get rid of or we can't avoid, unfortunately, is we got to pay our debts, we have to pay our taxes, final expenses, probate, all that kind of stuff has to get paid. So that's kind of number one on the distribution of assets. Number two is a specified gift. So, um, just to speed forward for a second, the residue is if you say, I'm leaving everything 50-50 to my two kids, if you have two kids, that's the residue. They're just getting everything that's left over after debts, taxes, final expenses, and probate are paid. The specified gift, though, would come before the payment of that residue. So you could say, I want each of my grandkids to get $50,000 to help pay for their education when they reach a certain age.
Mm.
Or you might say, I want X number of dollars to be left to my favorite charity, whatever that is, right? So these gifts would get paid out after all those final expenses are paid.
Mm.
So final expenses, then the specified gift, and then the final piece is that residue. So then whatever's left over is broken down and distributed to the beneficiaries based on however you've allocated that.
Right. And I think the next one that we're going to talk about is one that I think a lot of people do think about, but should, is planning for digital assets.
Yeah. So this is something that I guess just for however many hundreds of years of wills just was not talked about or discussed. So it's something that we see not addressed probably in 70 to 80% of wills still today, I would say. And so that is, I first of all, giving your executor authority to be able to access and deal with any of your digital assets. So we're talking about like email accounts, social media accounts, online bill payment accounts, like all that kind of stuff, right? So the first part is, there should be a clause in there just discussing, what authority is given to the executor, how they want that handled. And then the second part of that is the executor needs to be able to figure out how to get into all those accounts and be able to deal with them, right? And so that's where the estate registry comes in, which I'll talk about in a minute. But basically a place to keep track of everything. So this is something that to some extent, there should be at least some kind of clause dealing with that in your will. And I would say that if you haven't updated your will in the last couple of years, there's a really good chance that there's nothing in there dealing with it.
Yeah. And how about if we just jump to business owners and secondary wills for a moment?
Yeah. So everything that goes through your primary will has to go through the estate. And so anything that goes through the estate, you have to pay probate on. So in Ontario right now, that's about 1.5% is basically what it works out to. So if you have $1 million goes through your estate, that's $15,000 in probate. But not everything has to go through your estate. So one thing that does not is your shares in a privately owned company. Basically, you can have what we call a secondary will, which just addresses how are those shares to be dealt with? How's that ownership to be dealt with? So there's some other things that can go to secondary will as well, but that's the main thing we see there. So if you're a business owner, like with a corporation, then you should have that secondary will in place to make sure that your business doesn't unnecessarily go through your estate.
Mhm. And finally, just to wrap things up, after the will and POAs or powers of attorney are in place, are you all set?
Yeah, so we didn't talk about powers of attorney today, but there is your power of attorney for health, your power of attorney for property. You want to make sure you get those in place. We might do maybe another episode at some point on the specifics of those.
Mhm.
But yeah, so after you have those key documents in place, that's kind of step one. But step two is, and the reason that we're talking about this, I'll back up a little bit, is, we've had clients, children in our office kind of, overwhelmed and upset and crying because they, the documents have been in place to give them the authority to do what they need, but they can't find everything. They don't know what all accounts exist. And it's just very overwhelming, right? So it's great to have those key documents in place, but then you need an estate registry. So that estate registry is a place where you document basically everything your executors need to know. So that's going to be, what accounts you have, from bank accounts to investment accounts, where they are, what institutions, who your advisors are. So insurance, financial planning, lawyers, accountants. It's going to be, your digital passwords, right? And there might be another way to deal with that, which I'll talk about in a second. But location of important papers. So we actually, rather than me going through all this, Lindsay, if you could just maybe, we could link to or actually, if you just email us, info@retirementplanningsimplified.ca, and ask for the estate registry, we'll just send you a copy. So rather than me going through everything in the estate registry, if you want a copy of our estate registry to either use or kind of serve as the foundation for creating your own, you can just email us at info@retirementplanningsimplified.ca, and Lindsay will send you a copy of that. But anyway, the key thing there is making sure that your executors are able to find and access everything they need to be able to deal with your estate. And then once you've done that, it also is not very helpful if you have not told your executors where they can find that estate registries. So that's where the family meeting comes in, specifically if there is an executor who is a family member. But even so, if there's family beneficiaries, like, you want to have that family meeting. So that's going to communicate to your beneficiaries, why you've made the decisions you have, the consideration you've put into things. And again, where they can find all of this if they're going to be the ones that are dealing with it, right? And sometimes, I mean, it is not uncommon. And we had David Eady on, who told us some stories. We also did a client event recently where we talked about estate planning gone wrong. So there are a lot of scenarios where estates are contested, and I don't think any parent wants to see that, right? So just having that family meeting and communicating with your children what your thoughts are, and the considerations you put into your planning can go a long way to make sure that that never happens, right?
Mhm.
So that's very important. And then the last thing is, doing your estate planning is not a one time deal. It's something that you need to revisit on a regular basis, probably every 3 years or so, if there's no big changes. And if there's any life changes, then, we want to be revisiting that right away.
Thank you for joining us for this latest episode of Your Retirement Planning Simplified. Be sure to tune back in for the next episode. And until then, we're here to help you simplify and succeed in your retirement planning.